faithfully delivering value, interpreting great books from around the world. Hello, this is Sally Book Talks. Today, the book we're discussing is The Best Defense. Defense attorneys are a highly controversial role in the American judicial system. In many people's eyes, defense lawyers often defend bad people. Take the sensational O.J. Simpson trial, for example. The NFL star was accused of murdering his wife, Nicole Brown, and her friend. Prosecutors thought they had ironclad evidence, but Simpson hired a dream team of defense lawyers who got him acquitted, sparking huge controversy. Many said Simpson bought his innocence with money, calling defense lawyers accomplices to scumbags who let a butcher roam free. No different from murder itself.
This dazzling defense team included the book's author, Alan Dershowitz, hailed as one of America's most successful defense attorneys.
Beyond the Simpson case, he served as lead defense counsel in high-profile cases like Clinton's impeachment and Mike Tyson's trial. He's also a Harvard law professor and best-selling author. And remember Reasonable Doubts we covered earlier? That's his work too. Today's book, The Best Defense, isn't just another Dershowitz bestseller. It's required reading in top U.S. law schools. Drawing on decades of defense experience, Dershowitz argues most criminal defendants are guilty, and lawyers know it. Yet they must provide the best defense. That's the fundamental duty of legal professionals. Through cases he handled, Dershowitz explains why lawyers should defend the guilty and what makes a great defense attorney. Well, he also dissects flaws in America's criminal justice system and unwritten rules insiders see but won't discuss. Now I'll explore this book through two key questions. First, why should lawyers defend the guilty? Second, what makes a good defense attorney? Let's start with the first question. Why defend the guilty? The author gives 3 reasons. First, even the guilty deserve legal defense. Guilt is determined by juries or judges, not lawyers. The law must protect everyone equally. Bad people must pay for their evil deeds, but their basic human rights should still be respected. Secondly, defendants in criminal cases face prosecutors, meaning they're up against state power and are the weaker party, so they often need lawyers to help fight back. For example, compared to prosecutors, defendants find it hard to gather evidence or present the full truth on their own, so they need professional help from lawyers. Again, in the entire U.S. judicial system, no one cares about fairness and justice. Even prosecutors and judges who represent justice can have motives and actions that veer off from seeking truth and fairness. Their ultimate goal is to win. This sounds extreme and has sparked much controversy in legal circles. But the author says this comes from his experience. Many law students and new professionals idealize this profession, but there are harsh realities that law schools don't teach us, like the plea bargaining system and misconduct by prosecutors and judges. First, the plea bargaining system refers to an agreement in criminal cases where defendants plead guilty in exchange for concessions. And so, through this agreement, defendants waive constitutionally protected rights to get lesser charges or shorter sentences, turning punishment into a bargaining chip. For instance, a defendant facing a felony can plead guilty to a misdemeanor by waiving trial rights. Plea bargaining is recognized by the U.S. Supreme Court. In fact, about 3/4 of U.S. criminal cases are resolved through plea bargaining. Not just the U.S. Many countries have similar systems because justice systems need both fairness and efficiency, and plea bargaining boosts conviction rates while cutting costs. Plea bargaining also ensures prosecutors have a basic conviction rate. Once a defendant pleads guilty, prosecutors avoid court uncertainties, and case outcomes are crucial for their reputation.
But the author argues plea bargaining is easily abused in practice. Prosecutors, being more powerful, can coerce or threaten.
This can lead defendants to confess to crimes they didn't commit or admit to acts that couldn't be proven, resulting in wrongful convictions of innocent people. Moreover, plea bargaining often sparks controversy, making the public feel it's unfair and fails to give defendants proper punishment. Under pressure, prosecutors might also overturn plea agreements. The book gives an example.
Defendant Bernard Bergman ran nursing homes in New York. He was charged with 2 misdemeanors, but prosecutors chose plea bargaining. Bergman had a terrible reputation then, accused of elder abuse, money laundering through nursing homes, called New York's worst villain.
The evidence against Bergman was weak.
In fact, there was zero evidence for the elder abuse allegations.
New York prosecutors feared if charges failed, they'd face public outrage and media criticism for incompetence.
So they used plea bargaining to guarantee a win. Under U.S. law, Bergman should have faced separate federal and state sentencing with cumulative prison time. Well,
But per their plea deal, if Bergman pleaded guilty in state court, he'd serve no time beyond his federal sentence.
simply put, immunity in New York. But this agreement had a strange clause. It stated prosecutors would recommend, not demand, that the judge impose no sentence. Bergman agreed largely because prosecutors and judges hinted judges usually follow such recommendations. Yet federal court gave him only 4 months. The public was furious. Seeing this as too lenient, state prosecutors, fearing backlash, held a press conference, criticized the federal ruling, but said they'd honor their promise by recommending reduced sentencing.
Ultimately, New York's sentencing judge ignored prosecutors' advice and added a year to Bergman's term, a decision publicly applauded. Bergman appealed to federal court.
Federal judges ruled, while prosecutors' media comments were improper, they didn't violate the plea deal. Bergman had to serve the extra year.
This pattern extends beyond minor cases like Bergman's to serious high-profile ones, making plea bargaining a tool for prosecutors to secure wins. And one federal district judge, Jed Rakoff, once said, prosecutors have too much power. As of November 2015, out of 2.2 million Americans serving prison sentences, over 2 million had their sentences determined through plea agreements. Of those, conservatively estimated 20,000 were innocent. They, fearing retaliation from prosecutors during trial, accepted the deal and admitted to lesser or fabricated charges. In judicial practice, besides plea agreements, prosecutors and judges may also deviate in behavior for their own interests.
For example, to win cases, they distort facts, even blatantly lie, and conceal the truth.
First, let's talk about prosecutors and lawyers wanting to win, because their duty is to maximize their clients' interests and fight for them as much as possible. Therefore, their goal is to win. That's the professional requirement for lawyers.
But in reality, prosecutors' aim is also to win. To bring criminals to justice, they may commit procedural flaws, which itself violates fairness and justice.
For example, to protect citizens' freedoms and rights, the U.S. Constitution imposes many procedural restrictions on the government and its agencies, such as the Fourth Amendment, limiting the government's power to search, arrest, and seize property. These restrictions also include prohibiting illegal wiretapping. The Fifth Amendment prohibits the government from forcing anyone to testify against themselves in any criminal case, opposing self-incrimination. To enforce these constitutional amendments' protection of human rights, the Supreme Court established the exclusionary rule, meaning juries or judges cannot admit evidence obtained through illegal means, but law enforcement may violate it for various reasons. For instance, police and prosecutors knowingly use questionable witnesses and evidence, but operate improperly to solve cases and secure convictions. The book gives an example. A key witness in a case was a tainted police officer who had 3 prior bribery incidents, and prosecutors had already discovered more of his crimes, including embezzlement and theft, beyond bribery. If the jury knew about this, they might not believe the police officer's testimony.
To convict the defendant, prosecutors kept this quiet and lied to the jury, saying this witness was absolutely honest.
The jury believed the prosecution and found the defendant guilty. Having covered prosecutors, let's now talk about judges. Theoretically, judges should be the most committed to fairness and justice, since case outcomes don't affect them personally.
Yeah, well. But in the author's view, judges don't necessarily prioritize seeking justice. On one hand, some judges see themselves as part of law enforcement, doing whatever's legally possible to imprison defendants they deem guilty. Now, on the other judges focus on boosting judicial efficiency, clearing case backlogs, often lacking time and patience to fully understand cases, rushing through them.
More importantly, though, many judges have vested interests in case outcomes. These interests may affect their careers. In his book, Letters to a Young Lawyer, the author notes, judges seen as soft on crime rarely get reelected or promoted. Take New York federal judge Harold Baer. He once ruled drugs found without due process in a defendant's car couldn't be evidence. This legally sound ruling stirred up a hornet's nest.
During the 1996 presidential election, both candidates condemned him, and 200 Congress members demanded his resignation.
Though Baer later reversed his ruling with new evidence, his career suffered.
The government's message was clear. For promotion, judges must oppose criminals, even when contradicting the Constitution.
Highly educated prosecutors tolerate setting traps, ignoring perjury, protecting informants. They justify illegal or unethical actions as necessary to punish wrongdoers.
Sometimes judges even distort court records to secure convictions.
These practices blatantly violate the Constitution's spirit. In this flawed system, when both parties fully contest each other, rough justice can still emerge. True, some lawyers take cases for money or fame, but defense attorneys crucially enable clients to challenge the government and ensure procedural justice.
Why is this so important?
Because procedural justice is the foundation for substantive justice. What's presented in court or to the public may not be the full truth. Law enforcers' will and public opinion can both influence our understanding of truth and final verdicts. Moreover, everyone has different views on justice. Therefore, we must use relatively just procedures to ensure equal treatment for all cases and suspects, pursuing substantive justice through this. Sacrificing procedural justice risks wrongful convictions.
Secondly, procedural justice isn't about individual cases. Its purpose isn't punishing wrongdoers, but preventing more innocents from being convicted.
Take Bergman earlier. Adding 1 year didn't seem too severe. But for society, allowing government to casually break agreements under public pressure easily sacrifices fairness and justice. The author gives another example in the book. In January 1972, the Radical Jewish Defense League set simultaneous bombs in 2 NYC locations, killing 1 Jewish woman. 3 members were arrested afterwards. One named Siegel sought the author for defense. The author discovered Siegel was indeed guilty. He built the bombs and carried out those attacks. But Siegel had another identity. He'd become a police informant before the bombings. Police used illegal wiretapping and searches to obtain Siegel's criminal evidence, forcing him to become an informant.
Police and federal prosecutors promised Siegel immunity from prosecution and guaranteed confidentiality of his informant status.
Over the following weeks, Siegel provided tips preventing at least 4 serious terrorist plots. During this period, he continued participating in the group's activities, including those bombings. But after the bombings, the government quickly reneged, demanding Siegel testify as key witness. Siegel faced a dilemma. If he testified, prosecutors would drop all charges, but he'd be branded a traitor and possibly exiled from his community. But if he refused to testify, under U.S. law, he could face prison. Siegel seemed undeserving of help.
He was both a terrorist and a traitorous spy who betrayed his comrades.
The author himself faced immense pressure for representing Siegel, threats of disbarment and violence, rifts with friends and family. Yet, he insisted the government violated procedural justice. So, it's one thing for desperate government agents to use unconstitutional methods against potential disasters, but courts endorsing such acts to convict defendants is entirely different. Once unconstitutional acts gain judicial approval, they become part of constitutional principles, destroying the Constitution itself, ultimately harming everyone. Now, ultimately, due to the author's defense, Siegel neither testified nor was convicted for the bombings. After Siegel's acquittal, the author sat alone in the courtroom for a long time. He couldn't forget Siegel's victims. Ever since, he's taught this case annually in criminal law class, exploring its legal and moral dilemmas with students. The author argues, while heinous criminals are detestable, sacrificing their rights to eradicate evil or appease public fury represents the true failure of America's judicial system, especially its Constitution. Thus, we need lawyers to provide strong defense for the guilty. So what makes a good defense attorney? Let's elaborate on the second aspect. In summary, good attorneys need 3 qualities: prioritizing client interests, upholding ethical standards, and maintaining passion. First, client interests come first, fighting relentlessly within legal or ethical bounds to win for the client. Lawyers must place clients' lawful interests above all else, including their own career or personal morals. Some lawyers obsess over personal reputation. They play safe in court, never using creative tactics that could help clients, even sacrificing client interests. For example, to appear righteous, some admit their client's guilt before judges, abandoning defense. Some lawyers judge clients as good or bad, refusing to defend those hated by the public. But as we said earlier, defending suspects, guilty or not, is fundamental to legal ethics. Like surgeons in operating rooms, their sole goal is saving the patient's life. Whether the client is good or bad, even if they confess privately, and witnesses speak truth, you must cross-examine to find flaws in testimony. You can invoke the exclusionary rule to defend murder suspects. Even if you believe the client might kill again, you must first secure their acquittal.
This upholds constitutional procedural justice and prevents punishing people for crimes they didn't commit. Otherwise, punishment loses standards and risks harming innocence.
Many see lawyers as enabling evil, and they do face immense pressure, an unavoidable reality for defense attorneys. Otherwise, the defense system becomes meaningless. As the author says, before becoming a lawyer, you must redefine good as client interests above all. If this definition conflicts with your morals, perhaps don't become a defense lawyer. Even in cases with ironclad evidence, there's room for negotiation in charges and sentencing. The defense lawyer's duty is fighting within legal or ethical bounds to win or reduce sentences. Because justice systems are imperfect. Criminal cases aren't black and white, and prosecutors don't hold all truths. Lawyers shouldn't settle for known conclusions during defense. As famed judge Learned Hand said, the spirit of liberty is never being too sure you're right. The second quality of a good lawyer is upholding personal moral standards. When defending others, good lawyers fight relentlessly, even transcending conventional morals, a professional privilege. But this privilege mustn't extend to the lawyer's personal life and conduct. When a defense attorney isn't acting for a client, they must stick to personal moral standards and not cut corners for their own gain. For example, many top lawyers cozy up to clients for money, charging fees through stock dividends, giving business advice, even becoming directors at client companies, while ignoring how that likely breaks legal ethics rules. That's why top U.S. law firms often ban lawyers from investing in client companies and require strict approval for big roles like board seats. The book gives an example. A guy named Turner got investigated by state and feds for suspected pyramid schemes, so he hired lawyer Barry to defend him. Now, everything seemed fine up to this point, but then they signed a weird payment deal. Under this agreement, Turner hired Barry as his lawyer, paid all legal fees, and promised a fat bonus plus a private jet if they won. Barry didn't just defend Turner. He joined in recruiting members, making the pyramid scheme look legit and calming clients. But this got Barry in hot water. He got charged with conspiracy for fraud in the pyramid scheme. The author says, law ought to be a learned profession, not a business. But today, law is more like a business. Most law firms are just like companies, can't help but measure everything by the dollar. But since defense lawyers face all kinds of temptations and blurry moral lines, They need a rock-solid moral core more than anyone. So, what makes a lawyer good at sticking to personal morals? The author proposes a fluoridation test.
When the author was a kid, there was a big fuss over whether to fluoridate drinking water to cut down on cavities.
Most honest dentists backed fluoridation, even though it hurt their business. Fewer cavities meant fewer patients and less cash. Quote, some selfish dentists cooked up all sorts of reasons to tell folks fluoridation wasn't needed. God, bro, God, pro, God. Because dentists even said it's important for kids to get cavities so they can visit the dentist. And just as dentists can detect more serious issues, defense lawyers should ask themselves a similar question. Are they willing to sacrifice earning opportunities for the public good? For instance, the National Association of Criminal Defense Lawyers strongly advocates abolishing the death penalty and expanding legal aid. These reforms may reduce lawyers' caseloads, but promote judicial fairness. Republicans pro-law and cloud. The third quality of a good lawyer is maintaining passion.
Many believe excessive passion isn't necessarily a virtue for defense attorneys.
Defense lawyers often challenge government actions to protect clients, but the limits of such challenges remain undefined. Overly aggressive tactics can backfire.
But the author views passion as essential, since defending clients against government overreach requires tremendous zeal and courage.
Yet many lawyers lack passion, indifferent to clients, focused only on fees and quick resolutions to avoid trouble. All right, next case.
For example, the book describes a death penalty lawyer who didn't investigate the murder's context, ignored post-arrest client-police conversations, and even overslept during a critical pretrial hearing.
The defendant was convicted of murder, with no mitigating factors presented by the lawyer. Such passive lawyers face no backlash, since many defendants are guilty, but their indifference risks clients' lives and erodes public trust in the profession. The author admits his bold stance stems from being a Harvard professor, not dependent on litigation income, allowing him this freedom. This is far harder for ordinary lawyers. Moreover, passion fuels professional excellence and is its best catalyst. Successful lawyers should deploy passion strategically and moderately as a defense tool. For sustaining passion, the author suggests, avoid over-relying on strengths. Constantly challenge yourself. Also, don't be tormented by past wrong choices. Learn from them instead. With that, we've covered most of the best defense. Criminal defense lawyers face immense challenges. Many see them as villains who defend suspects, accused of greed and enabling evil. This is the criticism they must endure. Take the author himself. Judge Baer, who presided over the NYC bombing case, accused him of obstructing justice and letting murderers walk free.
For representing despised criminals, he was booed by students in class. His family refused
to speak with him, and dates stormed out from dinners. His hard-earned reputation as a civil rights champion suffered severe damage. Yet to the author, no title is nobler than defense lawyer, ensuring everyone's right to defense. It's the cornerstone of American liberty. Only when government can be challenged can fairness, justice, and the best defense prevail. That concludes our discussion. Reading notes are below the audio. See you next time.